I've heard the term surviving the contract, but what does that mean? And what's the difference in the survival clause in the GAR, Georgia Association of Realtors contract, and the RE Forms contract? Dana Sparks, broker of Maximum One Greater Atlanta Realtors and director of the Real Estate Academy of America. And today's topic has to do with survival of a contract, and more specifically, the differences between the Georgia Association of Realtors contract and the RE Forms contract and the survival clauses in both of those contracts. So in general, what does it mean when a provision survives a contract? Well, usually when a contract ends, the parties' obligations to one another end at the closing of the contract. In other words, they're contractual. The closing ends the contractual relationship, but there are some provisions where the contractual obligations continue even after that contract relationship is over. And in that instance, we say those obligations survive the termination of a contract. And more specifically, with respect to the GAR contract, the Georgia Association of Realtors contract, according to Seth Weissman, who was the original legal counsel behind the Georgia Association of Realtors with respect to their contracts, what Seth says regarding the survival of the GAR contract is the GAR contract itself does make no specific reference with regard to any sort of breach that occurs after the closing happens. However, contract claims after the closing of a contract are limited by the general principle of when the deed is conveyed from the seller to the buyer. And in essence, what Seth says is that, or I guess this is the legal, having to do with the legal issue of survival of a contract and deed conveyance. It says that once the deed of conveyance is delivered and accepted, the purchase and sale agreement is actually merged into the deed conveyance and doesn't survive unless the purchase and sale agreement specifically states or provides for something that, quote unquote, survives the closing. So let's look at the actual GAR contract, and let me show you what the survival clause is there. And then let me contrast with the RE Forms contract and show you what it says there. So I'm going to share my screen, and I am going to show you the GAR purchase and sale agreement. This is F201 GAR purchase and sale agreement, and it is paragraph C40 under survival of agreement. And it clearly states, let me make this just a little bit bigger. I don't want that. It specifically states that the following shall survive the closing of the agreement. In other words, after closing, when the purchase and sale agreement is done and the purchase and sale in essence merges in with the deed, what is still in effect, or what the parties' obligations are with respect to the contract that go past that time, are the following. 1, the obligation of a party to pay a real estate commission. 2, any warranty of title. 3, all written representations of the seller in this agreement regarding the property or neighborhood in which the property is located. 4, the buyer's indemnification obligations arising out of the inspection of the property and buyer's representatives. 5, the section on condemnation. 6, the section on attorney's fees. 7, the obligations of the parties regarding ad valorem real property taxes. And 8, any obligations which the parties herein agree shall survive the closing or may be performed or fulfilled after the closing. So let me just back into each one of these just a little bit. I'm not going to go into it as I would in a CE class. We cover this in depth in our CE classes, continuing education classes on these contracts. But for the purposes of this video, basically, even if the parties have not paid a commission that they owed at closing, they are still responsible contractually and legally to pay the commissions. The title, any warranties of the title survive the closing. All written representations of the seller in the agreement regarding the property or neighborhood. That has to do with anything that the seller warrants regarding the property in any sort in the contract itself, in any amendment, or in an exhibit, for example, in the seller's property disclosure statement. Excuse me. This section number 4 that was added by the Georgia Association of Realtors in 2023. And that is the buyer's indemnification obligations arising out of the inspection of the buyer by the buyer or buyer's remedies. And basically, just to point out what that is referring to, that is referring to a new paragraph in the Georgia Association of Realtors Purchase and Sale Agreement in 2023. It is under paragraph B8, and it is new paragraph D under the inspection and due diligence period. And it clearly states that I don't know if that's too big or not, that the buyer agrees to hold the seller and the brokers harmless from all claims, injuries, and damages related to the exercise of their inspection rights by the buyer or the buyer's representatives. And the buyer shall promptly pay the seller the actual cost to restore any portion of the property damaged or disturbed from testing or other evaluations to a condition equal to or better than the condition it was prior to such testing. So that whole paragraph, in essence, survives the closing. And then the next section was the part on condemnation. In other words, if the property has been condemned by the local county or city government, then obviously the property stays condemned even after closing. The section on attorney's fees, basically, if there are any issues that do go to court and the judge, actually it has it in here that the loser may have to pay the winner's attorney's fees, that survives closing. Any proration of the property taxes, if the closing attorney collects taxes based on last year's estimate and this year's bill comes out and it's different, the buyer and seller are still obligated even after closing to prorate the differences in the property taxes. And then this paragraph number 8, any obligations which the parties herein agree to survive closing shall survive closing, or anything that they have negotiated for to be performed after closing. This paragraph, this phrase has a lot to do with buyer and seller negotiated, for example, repairs, or if the seller agrees to pay for a home warranty for the buyer, so forth and so on. So as an agent, you need to remember this magic phrase: this provision shall survive closing. This provision shall survive closing. Okay, Dana, why is that a magic phrase? That is a magic phrase in the GAR contract because that will bring in a negotiation, an obligation between the buyer and the seller. And without that phrase, if it wasn't done before closing, it is not a legal obligation contractually after closing. But if you do use that magic phrase, it is. So let me give you an example. Let's say a buyer and seller negotiate for the seller to pay for a 1-year home warranty for a buyer at closing. And the agents forget to call it in. You go to closing, it doesn't get on the closing statement. You forget to call it in. And the buyer calls the buyer's agent after closing and says, hey, I need that information on the home warranty. Buyer's agent says, oh my goodness, I'm so sorry, we forgot to call it in. Let me call the listing agent and we'll get that all squared away. Buyer's agent calls the listing agent and says, hey, it was so great working with you. Remember that deal? Well, we forgot to call in the home warranty. So I need for you to call in the home warranty and have the seller pay for the home warranty for the buyer like they agreed to in the contract. And the listing agent says, so sad, too bad, that did not survive closing. Should have thought of that before we closed. And the buyer's agent says, so sad, too bad, but I took Dana's class and I watched Dana's video. And if you'll remember, we also included the magic words, this provision shall survive closing. So the seller is still contractually obligated to pay for that 1-year home warranty for the buyer. So that's just an example of a contract provision that without that magic phrase, this provision shall survive closing, would not survive closing, but it does survive closing with that magic phrase, because that all of a sudden pulls that into this last subparagraph 8, any obligations which the parties herein agree shall survive closing, or if they say this shall be performed after closing. That's the GAR, Georgia Association of Realtors contract. Now let's look at the RE forms contract. The RE forms contract, in the standard terms, which is RE1, the survival paragraph is under paragraph 12.7. And let me just read that to you. What that says in the RE forms standard terms 12.7, it states, unless expressly agreed otherwise in the contract, or unless provided otherwise in any other document executed by the seller and the buyer at or prior to closing, the provisions of the contract shall survive closing. Okay, Dana, what does that mean? That means the entire contract survives closing. The obligations of the buyer and the seller that they made to one another in the purchase and sale agreement do survive the closing if they're binding under the RE forms contract, because the entire provisions of the contract survive the closing, versus the GAR, where it is just these specific 8 items that survive closing. Now, if you are binding, if the buyer and the seller are binding under the GAR contract, and there are other issues that you want to survive the closing of a contract, not only could you use this provision shall survive closing to pull it into paragraph number 8, but there are a lot of special stipulations, and you will want to look at the special stipulations library in the GAR contract forms. There are several of them. For example, survival of conditions. Nothing, notwithstanding anything else contained herein. To the contrary, the parties specifically intend and agree that the following agreements, conditions, and stipulations shall survive closing. And then you itemize some specific things. Or another special stipulation would be unfulfilled conditions discovered shortly before closing. For example, if there's been bad weather and a buyer does a walkthrough and you discover the property has flooded when that wasn't discovered before closing during the contract, during any inspection. And there is a whole special stipulation for that in the GAR library of special stipulations. So again, just a brief contract tip. This is a pretty important contractual issue that you need to be aware of when representing your buyers and your sellers. But the main issue I wanted to bring to your attention was, number one, what does it mean to survive a closing? What are some examples? How can you bring something into survival status when it's not? and the differences between the GAR, Georgia Association of Realtors Purchase and Sale Agreement, and the RE Forms Purchase and Sale Agreement with respect to what survives a closing. Now, if you are an agent helping a buyer or a seller on any other contract, for example, a new construction contract, a HUD contract, Fannie Mae, Freddie Mac, or an attorney written contract, you will want to see what the survival clause is within that contract, or have an attorney draft a survival clause for you. And there might be, my understanding, you'll have to check with an attorney. I'm not an attorney, but my understanding is there are certain provisions or obligations that do merge at the closing of a transaction for real property, that merge the purchase and sale agreement with the deed conveyance. So you'll want to check with your favorite closing attorney on those issues and understand, if your buyers and sellers ask, what obligations are still in effect even after the closing of a transaction for the conveyance of real property. Whew. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors and director of the Real Estate Academy of America. That is also our website you can go to check out our classes. And I'll be more than happy to answer any questions for you on Maximum One as well. Thank you guys so much for watching. I try to satisfy your needs with service, innovation, and education. Bye.